The world is changing faster than ever before. In the past 10 years, there has been an exponential technological evolution, the kind of technology that has revolutionized the world of work as we know it.
The Lawyers Hub was founded on the principle that law needs to interact more with technology, and that greatly affects tech policy as well as access to justice. So the Lawyers Hub exists as a confluence between law and technology, working on tech policy, on emerging technologies, as well as increasing and upskilling the knowledge of lawyers in the area of technology. We support tech startups as well to ensure that the tech ecosystem also engages in policy, but as well understand issues around data protection, issues that also concern their structure, as well as intellectual property.
If you look at the evolution of technology, it's been relegated as an alternative in most systems. But the realization that 21st century has brought us into is that technology has to be an integral part of our day-to-day systems. And if you look at some critical technology areas like artificial intelligence, blockchain, nanotechnology, biotechnology, then it gives us a strong indication that if we do not start having discussions on the use of these technology areas, as far as law is concerned, then we may be in some kind of trouble. So lawyers are leading the debate on the use of these technologies, especially in Africa.
Over the years, the Lawyers Hub has supported the innovation ecosystem, convened events such as the Africa Law Tech Festival and the Global Legal Hackathon. The Lawyers Hub has also supported government innovations within the justice sector, as well as trained government institutions and more than 10,000 lawyers across Africa on emerging tech policy.
Our dream at the Lawyers Hub is to have open access to law. We envision a continent where there is access to justice through leveraging technology and with a crowd of enlightened lawyers. We see a continent that also protects its own through better tech policies, that emerging technologies, through its regulation, will offer better value and consumer protection for the people within Kenya and within the African continent. We envision that we will convene policy makers, regulators, as well as lawyers who are more enlightened on emerging technologies and with better digital skills. And we invite you to be a part of this great vision for Kenya and for Africa.
Good afternoon. Thank you for joining us. My name is Rispa Onyango. I'm a policy lead here at the Lawyers Hub, and I'm going to be your moderator for this afternoon. So welcome to yet another online policy discussion. And today we are going to be focusing on issues copyright. We are so excited to be collaborating with the judiciary as well with the Copyright Tribunal of Kenya to bring you this particular discussion. And our focus today is going to be the Copyright Tribunal Draft Regulations of 2022. I really do hope that you guys have been able to, interact with this document. My colleagues are going to be putting it on the chat section in case there's any one of us who hasn't gotten a chance to just go through it, so that you're able to follow our discussions and you're able to, give us feedback and we can be able to get your input. So the main purpose of this discussion is to be able to, one, sensitize us as to the function and the roles of the tribunal, and also as to the rules. So we are going to be looking heavily on these rules and then seeing areas of improvement, areas of feedback, and how we can just make sure that the whole enforcement and implementation around it is actually something that is suitable for the industry. So we highly welcome you to this engagement. Thank you for joining us. Feel free to chat with us on the chat section. Tell us who you are, where you're joining us from, what your expectations are with this particular session, and also feel free to put any questions that may arise on the Q&A tab, and we are going to be looking at those. And then also engage with us on the different social media platforms. So that is at Lawyers Hub Kenya for the Lawyers Hub, Copy Tribunal for the Copyright Tribunal of Kenya, and Kenya Judiciary for the Judiciary. So I think with that, those are the house rules, rules of engagement, and we are just going to dive right into it so that we are not wasting any time. So to kick us off, we're going to be doing a short presentation, courtesy of the Lawyers Hub, just to unpack a bit about the draft regulations as they are, the frameworks and some of our thoughts on that particular document. And then thereafter, we are going to now be inviting the members of the Copyright Tribunal to help us just have a discussion around, the framework and the structure that they have come up with. And then we can also be able to get your input and your insights on the same. So you're hoping that this is going to be a very fruitful engagement for all of us, and we invite you to be a part of this. So I'm going to welcome my colleague, William, who is a policy assistant here at the Lawyers Hub, to kick us off.
Okay, thank you very much, Rispa. So I'll go straight to the presentation, and we are going now to look at what does copyright means and why we need to regulate copyright. So when you're talking about this copyright basically is a legal concept that gives the creator of an original work the exclusive right to use and profit from that work. And this can include things like books, we have music, we have movies, software, and other creative works. So you find that generally countries do regulate these copyrights to protect the rights of creators and incentivize the creation of new works. So by granting creators these exclusive rights, you find that these laws seek to encourage the creation of new works by giving creators the economic incentive to invest time, energy, and resources into their creative endeavors. Then also you also find that copyright laws also serve to protect the rights of creators by preventing others from using their work without their permission. So you find that in enforcing these copyright laws, countries help to encourage creators to receive appropriate compensation for their work and to have control over their work, how their work is used, and how their work is also being distributed. So you find that these copyright laws can also have a framework whereby they can be used to solve disputes relating to copyright infringement and other copyright-related issues. So generally, in a nutshell, what we're trying to say is that copyright regulations plays an important role in promoting creativity and innovation. It's also protect the rights of creators and support growth of culture and creative industries. So I'll move quickly to the part whereby we are talking about why we need to regulate this copyright. So copyright basically is to protect the creators, also to give them the benefit from their work, and also to protect the infringement of such rights. Then the laws also is a platform whereby disputes relating to these copyrights can be adequately resolved so that we have amicable solutions of problems. So generally, I'll do a comparative analysis of copyright in Africa. And we are going to concentrate on various countries. So you find that the general reason why we regulate why countries regulate copyright is to actually adjudicate on dispute, protect their rights, and also regulate how these creative works can also be distributed and used by other members who did not actually participate in their actual creation. So you find that in the regulation of copyrights, we also have dispute resolution platforms, and for instance, we have the copyright dispute tribunals, which actually is responsible for resolution of disputes. So you find that several countries in Africa has established these copyright tribunals to actually adjudicate on dispute relating to copyright infringement and other copyright-related issues. So for instance, in a country like Ghana, but one thing that you're going to realize is that most of these countries do have these copyright tribunal to actually adjudicate on issues relating to copyright infringement and copyright-related issues. So you find that a country like Ghana has established their copyright tribunal under the Copyright Act of 2005. And the main function of this tribunal is actually to hear and determine dispute relating to copyright. So it also has other functions, which include the power to hear and determine disputes relating to licensing, infringements, and royalty payments. Then it also has the power to issue injunctions, award damages, and order for destruction of infringing material. The next country I'm going to look at is Nigeria. And in Nigeria, we also have the Nigerian Copyright Tribunal, which was established under the Copyright Act of 1988. So you find that its main function is actually to hear and determine dispute relating to copyright. It also has other functions like the powers to hear and determine dispute relating to copyright infringement, including dispute between copyright owners and users. Then also it also has the powers to issue injunctions, award damages, and destruction of infringing material. Then lastly, we are going to look at the East African country of Tanzania. And unlike the other countries, in Tanzania, the act is actually referred to as the Copyright and Neighboring Rights Act of 1999. And this is where they have established their copyright tribunal, which its main function is actually to hear and education. So you find that most of the African dwellers or the people in Africa are not aware of these rights and the responsibility under the various copyright laws. And some of them also do not understand the importance of respecting these copyrights. So you find that this leads to widespread infringement of copyrighted material, including things to do with the piracy of music, movies, and other creative works. Then there is also that issue of limited resources. So when you're talking about resources, we are talking about limited resources in terms of capacity to actually enforce these copyright laws. So you find that due to the limited capacity, these laws cannot be adequately be implemented. And since that cannot be adequate implementation, and there's also that lack of capacity, you find that investigation and prosecution of copyright infringements cases are limited, and this limits the extent to which these laws can actually be implemented. Then we also have the issue of inadequate legal framework. So you find that most of the African countries, as we saw during the study, they actually have inadequate laws, and some of them, even if they have the laws, they are actually outdated and they do not comply with the international standards. So you find that the actual enforcement of these copyright laws becomes a problem. And now, due to the inadequate legal framework that exists, you find that enforcing these laws actually becomes a problem, and the enjoyment of the rights of copyright owners also is inhibited to a certain extent. Then there's also that issue of limited access to technology. So you find that most people or most creators of innovative material actually has limited access to technology. So this leads to distribution and monetization of their work becomes very limited, and so they cannot actually benefit from the creation that they actually innovate. Then lastly, we have that issue to do with corruption. So you find that most African countries suffer from corruption and lack of political goodwill that hinder effective implementation of these copyright laws in these African countries. So generally addressing this issue will be key to promoting effective regulation of copyrights in Africa and protecting the rights of creators, as well as those people who would like to enjoy from these creative innovations. So from that, I will quickly move to, give me a minute. I will now look at the overview of the Kenyan system. So you find that in Kenya, we do have the Copyright Tribunal, yes, which is established pursuant to Section 84 of the Copyrights Act. And when you look at this tribunal, it is amongst the subordinate courts that established under Article 169 of the Constitution. And its basis of existence, or its core mandate, is actually to support the quest for fairness, equity, efficient, and also it's also include the use of alternative dispute resolution mechanism in the dispensation of justice. So quickly, I'll look at the draft regulations, and I'll first start with the object of these regulations, which are provided for by the procedure, and basically is to expedite the discharge of any dispute referred to the tribunal. Then you look at the guiding principles of these regulations that are contained in Article 10 of our Constitution. Then some are also contained in Article 159.2 of the Constitution. Then in addition to this one, we also have other guiding principle, that is to provide parties with an equal platform to prosecute their cases, and also to offer expeditious, fair, effective disposition of matters within the jurisdiction of the tribunal under the Act. I'll quickly go through an overview of the draft regulations. And in the preliminary section, we have the arrangement of sections. Then we have the short title, which provide for the Copyright Tribunal Procedures Regulation 2022. Then we have Regulation 2, which provide for the interpretation of various terms which are defined within the regulation. Then we also have Regulation number 3, which provide for the objects of the regulations. Then Regulation number 4, which provides for the guiding principle. Then we quickly move to part 2 of the regulations, and these provide for the administration of the tribunal. And some of the sub-heading included in this part 2 include the secretary to the tribunal and the functions. Then you also have the staff of the tribunal and the composition of the tribunal. Then we move to part 3 of these regulations, and it's provide for the appeal proceedings. And some of the things that are included within this subsection include filing of the appeal, service of notice of appeal, response to appeal, submission of parties, pre-hearing conference, procedure of hearing, decision of the tribunal, and also we have the electronic filing. Then we move to part 4 of these regulations, and this one provide for proceedings relating to compensation. And actually the subtitle that we have there is the application for compensation. Then we quickly move to part 5 of this regulation. This one provide for the pillar orders, including the powers to enter premises. It also provide for the identification of those persons who are actually authorized to actually go and enter such premises. So they must be identified according to they must identify themselves according to these regulations. Then we also move to part 6, which provide for dispute relating to registration of copyrights. Then part 7, this one provide for the miscellaneous provisions. And some of the subheadings included there includes summons of witnesses, provision for interested parties. Then we have representation. We have disclosure of interest by a tribunal member, orders to costs and fees to be charged by the tribunal. So during our analysis and the study of this regulation, we identified some areas which we felt as an organization that should be taken, should either be revised or modified to meet certain or to clarify some few points. So for instance, when you look at the secretary to the tribunal, you find that paragraph 1 mentions the appointment of the secretary to the tribunal by the cabinet secretary. However, there is no mention of the criteria or qualification required for such an appointment. So it was our recommendation that it would be beneficial to specify the eligibility criteria and the selection process to make it more transparent, so that you know that these are the qualifications needed of a secretary to the tribunal and how the appointment procedure will be. So we gave an example there, for instance, that the secretary to the tribunal shall be appointed by the cabinet secretary on the recommendation of an independent tribunal consisting of experts in the field of copyright and related rights, and the appointment shall be subject to approval by Parliament. So these are some of that is one of the recommendations that we put there, so that at least when the cabinet secretary will be appointing the secretary to the tribunal, we may look into that one. Then also in regards to the function of the secretary, the regulation provides for the responsibility of the secretary to the tribunal to include, among other duties, responsible for orderly and prompt conduct of business of the tribunal. But now, so one of our recommendations was that the cabinet secretary should consider adding more details on the specific functions of the secretary outlined in Regulation 6. By so doing, this will actually provide a clear understanding of what the responsibility of the secretary to the tribunals are and what is expected of him or her to do. Then moving on to the staff of the tribunal, The regulation provides that the Cabinet Secretary shall second such number of staff to the tribunal to enable it effectively discharge its functions under the Act. So that is what is provided for in the regulation. As Lawyers Hub, we recommend that we try to provide more details on the process of seconding staff to the tribunal, which is outlined in regulation number 7. So regulation number 7 also mentions that the Cabinet Secretary may second such staff, but there is no mention of the role and the responsibility. It would also be helpful to specify the role and the responsibility of the staff to make the administration of the tribunal more efficient and effective. We gave an example there, and I would say that the staff of the tribunal shall assist the secretary in the day-to-day administration of the tribunal, provide administrative support to the members of the tribunal during the proceedings, and maintain records and archives of the tribunal. So those are some of the functions that maybe when you go into details on providing the responsibility of the job description of the staff members, then I think it should go into details to actually elaborate what each and every member of the staff would be responsible for. Then moving quickly, there's data during the appeal process. So you find that there's data requirement for service, and the regulations provides that the appellant shall within a day serve the affected parties and the board with the notice of appeal. So you see, in as much as the objective of these regulations is to actually make the process more efficient and fast track the process of dispute resolution, but a service of 1 day was quite of a limitation to, or not only a limitation, but not everybody can meet depending on the complexity and the circumstances surrounding that particular case. For instance, you might be trying to serve someone who is not within the jurisdiction where you are at, and the limit for 1 day service might not be actually met. Then also when dealing with this electronic service, because those are one of the methods provided for service within the regulation, you find that you may actually think that you've actually done an email and you've actually sent it, but when you go into details and you find that maybe it was not delivered, or it was delivered but the other party had not actually received this email or have not gone through it, then this requirement of one day service is kind of a problem in its own. So as a Lawyers Hub, we were recommending if the service period could be extended to a period of at least 5 working days to enable effective service, service to be effectively done. Then moving on to pre-hearing conference. So you find that paragraph 13(1)(g) provides that the tribunal may hold conference to determine the possibility of alternative dispute resolution. However, it's quite the methods for alternative dispute resolution are not specified. So it's left upon the tribunal to actually decide on the kind of alternative dispute resolution that they may prefer. So it was our recommendation as Lawyers Hub that the alternative dispute resolution mechanism should be provided, or a list of possible methods should be provided. For instance, the regulation could provide that the parties may engage in alternative dispute resolution methods such as mediation, arbitration, and reconciliation. You find this one now gives the parties an option on which platform to actually go for, and depending on the suitability of the dispute before them, then they can approach the right tribunal. Then lastly, on the procedure of hearing, no, that's not last, the second last, I mean. So when you find that paragraph 14(1) provides that the term sufficient cause has been used to explain the circumstances under which the tribunal may direct hearing to be held in private. However, the definition of this term is not provided for. So it would be more advantageous if actually we could provide a definition for sufficient cause during the at the preliminary level there, where we have the section for definition. And maybe a probable definition would be sufficient cause, and for holding hearing and in private means circumstances such as protection of national security, confidentiality of personal information, or commercial interest. So you find that when the tribunal will now be determining whether or not to hold a session in private, then when they're talking about the sufficient cause, then we know what will amount to a sufficient cause. So that is one also a recommendation by the lawyers hub. Then lastly, it's regards to the Anton Pillar orders, which is provided for under the regulation. And when you look at it, there is no mention of the procedure for obtaining these Anton Pillar orders. The regulation are silent on the procedure of obtaining it. Then there is also no restriction on the use of an Anton Pillar order, such as the limitation on the types of evidence that can be seized upon entering this respective premise to actually retrieve this evidence. Then also the period with which the orders must be executed. So you find that these regulations are silent on those pertinent issues. So it was our recommendation as lawyers hub that we include clear procedure. The regulation include clear procedure for obtaining these Anton Pillar orders, include the criteria that must be met and the steps involved in the process. Then also, it was our recommendation that the regulation include restrictions on the use of these Anton Pillar orders, such as limitation on the types of evidences to be seized, and also the time limitation or the period within which these Anton Pillar orders should be executed. So provided an example there, and maybe the tribunal must consider using this one, that the regulation could be revised to include a provision stating that Anton Pillar orders can only be granted if there is a likelihood of evidence being destroyed or altered, and that the orders must be executed within 48 hours of being granted. So that's all from my side, and maybe I'll pass the baton back to my colleague Rispa, so that we may continue.
Give your inputs in terms of just contribution. I've seen a bunch of remarks on the chat section. So if my colleagues could be able to project that so that we can just have a look at what already people are saying in the room. I think there's one that states, I think the examples of functions of the staff members are too general. Specific duties and functions should be recommended to make it easier for the cabinet secretary. That's definitely one that we also took note of. Then we have the regulations regarding appeals arises out of section 2.3, I think, of the Act, which concerns appeals from decisions of the board. The board is the copyright board situated at NHIF House. Therefore, one day is more than enough of service for Tuke Kobo. So there's someone who's of the view that the service notice is enough. So thank you for those. Kindly keep them coming. We're definitely going to be compiling all of this. At least we still have some good time. We are thankful to the tribunal who's given quite some time in terms of putting in your submissions and giving in your remarks as regards to these particular rules. Now to go on, we have them in the room, and we are so glad to have the members of the Copyright Tribunal actually with us so that we are able to unpack where it is that they are coming from in putting together this particular framework, so that we also hear their perspectives and get their views on the same. And then thereafter, we can also be able to just have an interaction between everyone in the room and you as well online. But in the room, I mean you as well, to get all comments on the same. So with me, we have the chairperson of the Copyright Tribunal in Kenya, that is Miss Liz Lenjo. She's here definitely in her capacity as the chairperson. She's a consummate IP, fashion, and entertainment lawyer of good standing for over 7 years. And she has handled legal projects and briefs in various African jurisdictions, as well as outside Africa. And this including Rwanda, Burundi, Botswana, South Africa, Ghana, the USA, and the United Kingdom. So she's going to be joining me on stage shortly. So I'll ask her to make her way here. Then we have Mr. Joseph Kihanya, who's a member of the Copyright Tribunal. He holds an LLB from the University of Nairobi, as well as an LLM in media and IT law from the University of New South Wales, Sydney, Australia. He has had training with Fahamu, Oxford University 2005, campaigning for access to information law, Oxford 2004, and 2009 in the Annberg Oxford Summer Institute in Global Media Policy, that is particularly a program in comparative media law and policy, and the United States Telecommunications Training Institute as a diploma in 2014. In the 10 years he's been in practice, he has worked as a communications law expert, where he was the head of advisory legal services in liaison with the Office of the Attorney General. And he was also responsible for leading the Ministry of Information Communications and Technology strategy, as well as the tactical legal services when it came to the constitutional review processes, which culminated in our constitution, of course, the treaties, the bills, the acts of parliament, the country positions at international organizations, such as United Nations International Telecommunications Union, the Universal Postal Union, the IGF, that is the Internet Governance Forum, and the Governmental Advisory Committee of ICANN. So welcome to the podium as well. And we also have with us Helen Munganya, who is an advocate of the High Court of Kenya and also the managing partner at K&M Law Associates LLP. And she's also here in her capacity as a member of the Copyright Tribunal. So I'll ask them to join me here so that we can be able to proceed with this engagement. So yeah, thank you so much, members, for joining us for this particular discussion. I think it's usually very fruitful when you have the guys who are pioneering the framework actually in the room to give you where they were coming from when they were putting together the framework. And so to kick us off, I'd like you to maybe just give us a premise of where you are coming from with this particular regulations and the framework that you have adopted, as well as some of the issues that you're seeking to cure in putting it together. So we'll hand it over to you, and then we can be able to do a more interactive session after.
Okay. Thank you so much, Lawyers Hub. Thank you everyone for joining us online. I think it's a very good day today that everyone is involved in this legislative process. So where are we coming from? We're basically trying to give teeth to the tribunal. The tribunal has been there for a while, but it has not been operational because, as you know, regulations are what help a tribunal to sort of kickstart its operations. We've borrowed from other tribunals in terms of how they have drafted their regulations. We had the Kenya Law Reform Commission assisting us in this process, which has been an intense process. And this is a process that started back in 2018 when Dr. Mutai was the chairman, and now we are able now to see this through. Of course, we've had the act go through a couple of amendments since then, I think twice. So we've managed to also incorporate those amendments, and we have tried to put also a document that Kenyans can interact with without any issues. Accessibility was important for us. So even when you look at the forms, we've tried to be very clear in terms of the language, in terms of formalities. We're not too formal because that's the essence of a tribunal. Access to justice much easier. It's expedient, understandable. Like, Wanjiko needs to know how to move the tribunal, and copyright is everywhere. Yeah. And then something else is that, as as we're interacting with the tribunal as well, eventually we'll manage to fine tune and push for more amendments. You see, the other problem we have been having is that the Copyright Act hasn't been tried and tested per se, especially when it comes to matters copyright infringement. So now here we have a formal tribunal, we have an avenue for dispute resolution. So at least it's a good start in regards to that. I think I can pass on the mic to my fellow panelists.
Thank you. Thank you, moderator. I think the main object of the regulations was to put in place the framework for the hearing of disputes before the tribunal, as mandated by the Act, so that for the most part, the regulations follow the mandates of the Act, so that we were really not trying to go out of that, and we were guided, of course, with the assistance of the Office of the Attorney General, with finding a way to have proportionality in the manner in which we engage with disputes before the tribunal in as fair a manner as possible, so that justice is dispensed. And we were looking also at, which is an aspect that runs through the regulations, is that there's a duty also on the parts of litigants, so to speak, or parties in the dispute before the tribunal, to assist the tribunal to get to a quickest and fairest conclusion of the dispute before. I think that's what I may say at this juncture.
Helen, kindly.
What I would say is that the regulations are providing a framework with which the people who have disputes, whose copyright has been infringed upon, can lodge their disputes before the tribunal. It also provides the forms that will be used, which, as our chair has already said, are in a simplified form. So I would not repeat what my colleagues have said. That is basically what the regulations provide for.
Okay, thank you for that. And I think my throat is trying to fail me, but we shall not allow it to do so. And I think I'll just follow up on what both Liz and Joseph have talked about. And first will be the ease in which, when you're interacting with that document, there's an ease to it. And so my question is coming from a place of where is the danger of missing out on a few things when we're trying to address Wanjiko. And this is coming from even the comment that we found where we are getting that not much detail is going into the rules in certain aspects. And so are we able to kind of make that balance where it remains easy, but we also are able to interact with everything that's needed for the procedure?
So one of the things we need to, just make people aware of is that when we're drafting regulations, we're not trying to replicate the law, right? Mm-hmm. We're basically now giving guidance. Mm-hmm. So when you look at our regulations, we're doing a lot of reference to the Act itself in terms of where it provides for the tribunal and how we are meant to conduct ourselves. Mm-hmm. So even when you look at even our timelines, mm-hmm. the tribunal, our copyright tribunal has very expedient timelines. Yeah. We are supposed to give a judgment within 30 days from when an application is made or an appeal is made. Yeah. And the other thing is also, the document has to be simple and straight to the point, because remember, in our tribunal also, you don't need legal representation. You can come in as yourself and represent yourself. So which means then it's a document that you can easily look at and say, oh, I have this kind of appeal. I have a dispute of a copyright registration. I will go to rule number X. I need this form, and the form is simple, and it already guides me the kind of documents I need to put together to come and also lodge them online and commence proceedings. Okay. So we've really tried not to replicate the law, because that's always the danger. And as lawyers, we can be very verbose. Sometimes we want to flex. Yeah. Like, oh, I know all this English. So we're really working away from that. So of course, even just to tell Kenyans, we have Kenya law, So for those who want to refer now to the Civil Procedure Code when it comes to Anton-Pillar orders, for example. So you find that this document is not operating in isolation. It will be, relating with the different legislations and work together in absence of any regulations. Again, the CPC, the Civil Procedure Code, would then come into play. So like I said, because the Copyright Act itself and the matters of, disputes under the Copyright Act have not really been explored in a huge manner or in an extensive manner, there will be some things eventually we'll slowly be adding because we're now seeing sort of gaps and whatnot. Yeah.
Okay. Joseph, as you touched on the overriding objective of these particular regulations, we noticed that we are being guided by the Constitution, of course, as Liz has mentioned, but then also you find that in other jurisdictions that this particular part it's quite detailed in terms of trying to satisfy exactly what it is that the tribunal is supposed to be doing. So I think from your perspective, would you maybe just unpack this for us so that we see what is the main objective of the tribunal? And also whether it's necessary to put all that detail within, or do we just premise ourselves, as Liz has mentioned, on the Constitution or any other alternative legislation?
Thank you, moderator. I think fundamentally, ours is our scenario in relation to the jurisdiction of the tribunal, I think, is quite different from perhaps what was being cited before by the presenter earlier. The jurisdiction of the tribunal under the Copyright Act is, for perhaps lack of a better word, it's very precise and very limited. So that you'll find we can talk about Articles 10, Articles 45, and Article 159 of the Constitution. That is essentially what we are trying to do in relation to access to justice. But the vast majority of cases in relating to copyright infringement are unlikely to come before the tribunal.
Yeah, that actually preempts my next question on jurisdiction, because it will be nice for us to really understand the scope that you're going to be covering. Because, for instance, I noticed that I think it's in Nigeria, it really focuses on copyright infringement. But then when you look at China, or I think Barbados, they focus on those commercial elements between CMOs and the commercial use of copyright. So maybe you could help us unpack just the jurisdiction of this tribunal.
Yes, I think it's historical. It's historical, and it came about at the time, I think it was 2001 when the act was passed, and there was the mandate that was given to what is now Kekobo. And then the rest of it was left to what you want to call the regular court system to handle in relation to infringement. Matters such as, for instance, Anton-Pillar orders, these are matters that could have been dealt with even before the Constitution of Kenya 2010 by the High Court or by the magistrates courts, depending on how the parties approach the court for those orders. So that I think the drafters of the act tried to find what you'd want to call a place for an appeal against an error by the board. That is essentially what it was. Now, remember also, and this is may come as a surprise to many, copyright does not exist by registration. You don't need to register your copyright, so to speak, but it's a procedure that is in our laws, and those who want to take advantage of that for purposes of their own protection of their own rights, they may do it. But you may create your own copyright work and perhaps not register it, but that does not mean that you are not conferred with the rights that the Copyright Act envisages. So when you find, therefore, that, for instance, one of the main aspects of the dispute before the tribunal is failure to register a copyright, you will find then that is not a very extensive jurisdiction, because there are perhaps many people who will not seek registration of copyright, although Kekobo does encourage a lot of people to register copyright. So you will find, I think maybe out of an abundance of caution, or out of the experiences that they were looking at, the drafters and Parliament at that time, they found out that maybe as a preliminary, maybe this is the mandate that should have been given to the tribunal. So we as a tribunal are stuck with the mandate that we are given. We can't expand it until such time as perhaps there is a recast by Parliament on these issues. And we're just trying to provide for a way, especially questions relating to the existence and the continued existence of collective management organizations, because they interact in terms of their licenses with Kekobo, which grants them the right to exist, so to speak. So those are the two aspects that we will ideally be dealing on. Questions about perhaps the grant of licenses in a reasonable, what do you want to call a reasonable manner by the CMOs, maybe that question we can look into. And that is where then I think what the previous speaker was talking about, that's where ADR comes in, because we would encourage, for instance, that you as a rights owner and somebody else, if you're having those negotiations, then ideally we as a tribunal may be able to grant an order or on some of those aspects, but most of the information on what you think what is worth will be coming from you and the parties. And that's what we would, in those circumstances, want to provide and have provided for the existence of ADR in the regulation, so that some of those aspects can be dealt with by the parties, maybe in another forum, and then they record it with us and it becomes an order that is enforceable. Okay.
I will allow Helen to also contribute on the same, if you have any further comments.
Okay, in addition to what my colleague has indicated as the functions of the tribunal, we also be receiving disputes from any persons who have failed to get a license due to imposition of unreasonable terms and conditions by the board and also by the CMO and the collective management organizations. I think that is what I would add on the role of the tribunal.
Okay, so thank you for that. I'm seeing a lot of engagement on the chat section as well as the Q&A. So what I'll do is I'll just quickly finish a few of the practices that we observed and maybe get the input of the members. Then we can be able to also tag at you and answer some of the questions that you've already put up. So kindly just bear with me for a minute. Now, I think what I would also like your input on was some various aspects that we also saw in some of the other jurisdictions that we were looking at when we were trying to compare the different roles out there. And I think in terms of the breakdown of the roles of the secretary, I think that's something that can be addressed. But I think let me focus on another two issues that I'd like your input on. And that is one with regards to being able to publish the applications being filed with the tribunal. So we found it as practice that once the secretary receives certain filings or application, then there's that requirement to be able to publish this, whether it's on their website or whether it's with a national gazette or whatever. And then they're being able to kind of invite whether it's interested party or interventions on the same within a particular period of time. So I'd like your guidance on whether this is actually accommodated within our procedure, our laws, in any one aspect, or if it's something that we can be able to consider to adopt in our jurisdiction.
Sorry, moderator. I think on the question of intervention, largely, and this is for the majority of the disputes we anticipate to deal with, there is the preponderance is that this will be filed in the e-filing system of the judiciary.
Okay.
So that I don't know what it would take for then these matters, because the matters are public. In the sense that once you file a case, that's a public record.
Yeah.
So I do not know whether there would be funds or convenience or even need for you to then republish the dispute in another public what did you call it, a gazette?
Whether it's the website, just an incentive of
Just
the
an incentive.
tribunal.
Okay,
Yeah.
maybe on the website, and then maybe the publication of that in what you now refer to as social media outlets, so that then parties can know that there's a certain dispute going on. That certainly can happen, but ordinarily, once you file, then that becomes a public record, and subject to perhaps maybe a requirement that there are orders that may be made that are adverse to somebody, because I'm seeing your request coming from the side of, for instance, what we see in the Kenya Gazette in the grant of administration of estates, where you have to publicly put that out, so that people who can object then can come forward. It's an interesting question. I think we can look at that in relation to the question of interveners, but certainly there will be room for the tribunal, granted the proper channels, to publicize what it is that is before the tribunal, so that those who want to intervene can intervene.
Okay.
Yes.
Is there any further input on this, or?
I think just something to add is, when you look at the nature of copyright disputes, and especially what is narrowed down in the Act currently, you will find that the parties who need to know will know. Okay. And then anyone around that circle who may feel like they need to be an interested party would subsequently know. And just as we look at the jurisdiction of the tribunal, I think one thing that was, I don't know if it came out clear, was that we also have the authority to determine fair compensation, where I think a musical works is used in a broadcast without authorization. I feel like that provision, I thought, was not completed, because the fair compensation should be across all types of copyrighted works that have not been used without authorization from the author. So of course, in the coming times, we'll be looking through that and lobbying for better provisions and for some amendments, for sure. And then the other thing is, in the case of a foreign works, where an author refuses to grant a license in the Kenyan market, Kekobo would hear such a matter. And then if the author is not happy with Kekobo's decision, then they would come to us and say, you know what, we feel like Kenya Copyright Board's decision to give access to a book was unreasonable or whatever. And then we would determine, that situation. And then, of course, the issue of the dispute of a copyright registration. Unfortunately, the way we read it, it means if there's a registration, it means someone can come and either defend or ask that the registration be investigated. Was this a rightful registration? Did this registrant perhaps do some underhanded behavior, sort of thing? And then, of course, now there's the provisions under 48, which is decisions by Kekobo with the CMOs. So where in instances Kekobo grants CMO licenses, right? So if they have not been granted or they're being restricted, then the CMOs would come to us and say, hey, Kekobo is being unreasonable or whatnot. And then where CMOs themselves are, restricting access to some of the works that they are supposed to license, then, a consumer would come to us and say, hey, I was trying to seek a license from MCSK or CAMP or PRISC, and it was not granted, and I'm here for you to assist, sort of thing. So of course, eventually, this will be fine-tuned. We have already started conversations in terms of how can we make it better. But I think, just looking at this limited jurisdiction, we are cognizant that, we've done a good thing. We have a specialized tribunal. So again, this does not stop anyone from even, having like a submission clause and saying, what, in the interim, as we are figuring out our legislative issues, in any copyright related contract, they could even still submit to the copyright tribunal and say, where we have a dispute of a copyright matter of whatever nature, infringement included, if the parties are happy to appear before us, it's a case we're happy to assist with and dispense justice while we're waiting. So we can't just say, what, in the meantime, our hands are tied. There will always be sort of provisions. And I think that's one of those pragmatic solutions I would offer and say, what, you're welcome to the Copyright Tribunal. You have an issue, come to us. We have an open door policy, and we will assist. And where you can submit as parties, please do so, and we will do our best to give honest, transparent judgments or rulings that are pegged on the law, that are pegged on the principles of copyright as we move forward. Yeah.
Okay. So I'm going to also seek guidance on the issues around being able to withdraw an application, or also in areas where there's non-appearance by either the party lodging the application, either or. We noted that the rules are silent on this, and so maybe we can get some input from you.
Okay, thank you very much. The tribunal will also be applying the civil procedure rules. So any party that has filed a dispute before the tribunal and gets to a point where they wish to withdraw, there is a process for withdrawing the application from the tribunal. So they can approach the tribunal and withdraw that application, since you'll also be applying the civil procedure rules.
Okay. Yeah, I think those were my tidbits on the same. So okay. Okay, I've just been notified that we have 2 tribunal members who are joining us online. So yeah, I'm going to just welcome them to the panel as well. So I think, as Liz mentioned, this is definitely a very open door tribunal, where you're really able to interact with many of the members and be able to get assistance. So we have Caroline Omanya joining us, as well as Wilfred Lucy. So I'm just going to be able to allow you to give us any remarks or input that you may have had, just based off our discussion so far. And then after that, we can now be able to engage with the participants in the room. So I'm going to start with you, Caroline. Kindly just introduce yourself, give us the background of your work and practice, and then give us your comments. Then we'll move on to Wilfred. Thank you.
Thank you very much. Good afternoon, everyone. My name is Caroline Omaya, an advocate of the High Court with 16 years experience. I specialize in commercial and conveyance law, and I've also done a master's in international financial regulation from Strathmore University. Just to input what my colleague Helen had answered, and I can see there was a question on the chat on whether the civil procedure rules will actually apply to the tribunal. The answer is actually yes, because we are looking to work towards that as a guideline of how we intend to operate within the tribunal. Thank you.
Okay, thank you for that, Caroline. I'll move over to you, Wilfred.
Yes, thank you very much. Good afternoon, everyone. As has been mentioned, my name is Wilfred Lucy, member of the tribunal. I ordinarily practice with the firm of CM Advocates. I'm an advocate over 11 years post-admission. I have particular interest in dispute resolution and matters intellectual property. I think just a general comment, without taking away from what my colleagues have been presenting on as far as the regulations are concerned, I think it's just important to underscore that the regulations that the tribunal is seeking to have, validated by its various stakeholders and consequently applied in resolving disputes that would fall within our jurisdiction, are essentially with the sole aim of making the tribunal more accessible and simplifying the processes that we have as a judicial or quasi-judicial body, and at the same time helping with predictability on how the dispute resolution processes would be managed within the tribunal. So looking at the essence, and I had my colleague Kimaya speak about this, Joseph, on the primary objective of the regulations really is to easen the access of justice on matters that fall within the jurisdiction of our tribunal. So I think as a general comment, I'll be happy to just leave it at that.
Okay, thank you for that, Wilfred. So now I'm going to move to our audience, and we can't have this discussion without you who are supposed to contribute and engage with this particular framework. So I'm going to start with the chat section and look at some of the comments that have been put there. Feel free to raise your hand. I see someone has already raised their hand. So let's allow them to first talk so that we are just sure we're not dealing with chatbots over here. So we'll allow George to go ahead and maybe pose his question or comment, and then I'll go to the chat section and the Q&A, and then we can take it from there. So you're welcome, George.
Thank you very much. I confirm I'm not a bot. I'm an advocate of the High Court of Kenya. I'm a practitioner. I'm very happy to be here. I have a comment, then I have two questions to the members of the tribunal. A comment in the sense that I also do agree that we need to start looking at how we are going to expand probably the limited jurisdiction of the tribunal. But the good thing is that we do now have a tribunal which is about to kickstart. So we are better off offsetting and starting off with the limited scope we have as we build capacity on other areas. My first question is in regards to Regulation 24, and I was just thinking out aloud. Maybe you guys can help me brainstorm on this. Regulation 24 deals with the disclosure of interest of members, whereby the rules are trying to provide for instances where there might be conflict of interest. The way it's drafted, it seems to be, I'm just wondering what happens in instances where in a particular matter, most of the members seem to have an interest. What's the procedure? Do we defer to the High Court? Because the way it's drafted, it's like you've foreseen a situation, and we are all practitioners in this field. Is a small field, so chances are that past relationships or existing relationships might restrict members from happening. What happens where all the members seem to have an interest? That is the first question. And then the second one, having been a practitioner in this field for a long time, I will not be surprised that one of the biggest challenges you will have are witnesses who don't follow simple instructions. What kind of teeth do you have as a quasi-judicial organization in terms of dealing with non-cooperative witnesses? Because some of these guys, I'm sure, will be boycotting summons, will be not be producing documents. It's been the order of the day. It's a struggle in the High Court, but at least with the High Court, the rules are a little bit more clear and defined because of tradition. But from your perspective, I know from the rules, as a person appearing before the tribunal, you can raise any issues in regards to how you want to prosecute. But how will you guys respond to uncooperative witnesses? I wish you all the best. Thank you very much.
Thank you so much for that, George. So we'll take the two questions and then we'll move back to the audience. Yeah. Either or.
I'm happy to go first.
Yeah, okay.
Okay. Wilfred, will you go first?
Wilfred, help us there on the conflict.
Yeah, I think the concerns that are being raised, it's a real concern, and that's why the regulations have anticipated it and sought to cure it. So that it's important that it's brought out. But yes, in trying to come up with the regulations, we were alive to that possibility. But now, if we look at the primary provision that establishes the tribunal, that's Section 48 of the Copyright Act, it talks about the constitution of the tribunal. So that the tribunal will be properly constituted if it has not less than 3 members and up to a maximum of 7. So at presently we are a membership of 5, and I would find it extremely unusual if there's any one particular matter where at least more than 3 of us are conflicting at the same time, because then that would pose quite a significant challenge in as far as accessing the original jurisdiction of the tribunal is concerned. But perhaps just to try and answer that, out of the 5, of course, 1 being the chair and then the 4 being members, the Act anticipates that where 3 of us are able to sit, and that's a properly constituted tribunal for purposes of conducting a particular sitting. So that I would think it would be highly unusual if we are unable to get 3 members who are not conflicted in any particular matter. I think that would be my comment on that. But it's important that, because you see, even if you look at court, it's not always that where it appears that there's an appearance of conflict that particular judicial officer would perhaps require to recuse themselves from that sitting. And if you look at the regulation, we tried to word it in that sense, where that interest would be disclosed. So that you might find even where a member raises a particular interest, the parties who are appearing before the tribunal might say, no. Looking at the nature of the interest disclosed, we don't think it would interfere in any way with your impartiality in as far as resolving this dispute is concerned, and therefore waive any objection we would have in having this specific member sit in this particular matter. So there are avenues that would be available, one of them being a reduction in the number of members who are sitting in a particular panel, or alternatively now even the parties who are appearing before the tribunal electing to waive any objection that they might have.
Okay, thank you for that, Wilfred. The second question.
Yeah, that was, I think, on the witnesses who are, did you say unwilling and cooperative?
Yeah.
I'm not quite sure. I don't know. Is it George? That's his name?
Yes.
Yeah, George. Sorry. I understand the environment that exists in relation to generally our adversarial judicial system, but I think this has been explored elsewhere, especially in criminal trials. We are not likely to declare witnesses hostile, but we'll certainly want to perhaps give parties a lot of room to make sure that their witnesses and their evidence is standard, so that we can reach a just and fair conclusion.
Yeah.
So at the moment, I think until that question arises, that we will be looking to see that we do our very, very best to ensure that we have all the material we need to reach a fair conclusion to a matter.
It's actually caused me to remember the issue around the pre-case management bit. I see that it's been captured within the structure of the rules, but I think, as you're saying, if we could have it cover a bit more ground in trying to just go through the particulars and trying to rule out what does I need to know. Finally, the matters that you're handling, if there's a way that can be handled at that particular first juncture, I think that will be really, really fantastic.
Okay, pre-trial conferencing. I think we'll try and firm that up so that everybody knows that that's a procedure we follow, and so that by the time the proper hearing comes, then everybody is at par with what we're up to.
I think something to add is that we have to remember that we're supposed to be a flexible tribunal. So if we get lost in a lot of red tape, then we'll become a deterrent, right? And when you look at the nature of copyright disputes, they tend to be very they have certain nuances, right? So if we have certain red tape, then to get to a point we'd be stuck. We'll be like, you know what, because this goat does not fit in this shed, then we have no room. We don't want to be in such a situation, right? So I think even for the lawyers who are here, I think that's really important to factor in and remember. So even after we've taken these comments, we have to be reasonable. We have to be reasonable within the practices. Kenya law reform will also give us guidance in terms of the drafting, and where there'll be clarification, perhaps we'll do like a guidance note and just say, you know what, if there's issues if you need clarification, look at X, Y, and Z. However, our plan is to be a very flexible and almost limited red tape. Aside from what is within the law, we're not going to try and say, you know what, you can't appear before the tribunal if you don't have a law degree or you're not a practicing lawyer. We really need to refrain from that. So we'll definitely, for every situation, there will be that balance, that analysis, and where there is case law, we will look at that. Then of course, there will be also principles of justice and say, you know what, in this instance, X and Y is missing. This is where we're making this decision. And should there be an appeal of our decision, even the High Court would be able to see that it was rationalized, that it came from a point of access to justice, not just on a whim.
Okay.
Yeah.
That makes a lot of sense. And so let me tag at Ivy Chege, who said, I agree with the civil procedure.
Can I add something there? I think there's an important point to just add, sorry, because it sounded like part of the concern George was raising was where we would end up having an errant, say, litigant, or even a litigator for that matter before the tribunal, one who just flat out refuses to comply with directions, say we agree, pleadings would be filed within certain timelines, or even certain directions are being made by the tribunal, say even an Anton Pillar order, for instance, and a party declines to allow access or whatever. There's just an attempt to frustrate the proceedings before the tribunal. I think that's part of the concern George is expressing. I think we should also remember that at the end of the day, the tribunal is, if we are looking at Article 169 of the Constitution, of the status of a court, so that the authority that a court would otherwise have to sanction a party that appears to be in contempt of its authority would be available to the tribunal, so that if a party appears to be frustrating the expeditious determination of a matter or frustrating the realization of certain rights that have been conferred out of proceedings before the tribunal, then there's the inherent right that the tribunal would have to call that party to order within its jurisdiction as a judicial, organ. So I think it's also important to just add that to the comments that my colleagues have made, in as far as how the tribunal could go ahead to ensure there's compliance with directions that it gives or orders that it issues, and proceedings before it are not taken for granted, even as much as we ensure that they remain relaxed.
Yeah. Thanks for that, Wilfred. I was quoting Ivy Chege, who's talked about agreeing with the civil procedure rules and the fact that they should apply to the Copyright Tribunal. She notes that the same isn't within the draft regulations. I suggest that a clause be added to the draft regulations and be specific on the extent of application of the Civil Procedure Act as read with the rules thereto. Could the Evidence Act also be invoked to the extent of its application? And so I think that touches on just the question of whether we can actually have express provisions which allude to the civil procedure rules as well as the Evidence Act. So that's a question we can float. And then I also noted there's another question with regard, we can go to Winnie, should be Winnie. Winnie Kamau, who talked about, I would like to ask a question of the protection of rights of those who have not copyrighted their work. I look at a creative like David Moyer, who has been doing dance shows creatively, but how does he copyright his work? I think Liz talked about that at the start, so maybe we can rephrase that. Then we have Paul, who's talking about, will there be instances where the tribunal will play the role of an arbiter between the aggrieved party and Kekobo? So that's another question that has been floated. And I think there was a question by a counsel, I think anonymous attendee, yeah. I'm talking about a counsel with a client whose copyright has been infringed pending the enactment of the regulations, which is the right court to seek redress in terms of the damages against the infringer. So I think we can take the three. So in terms of just having an express explanation as to the civil procedure rules as well as the Evidence Act, and then the issue around being an arbiter, as well as someone who hasn't actually registered per se, because ideally copyright falls to you whether you register or not. Yeah.
Carol, would you like to say something?
Yes, I'd like to start with a question on whether what happens in terms of the comments about being specific with the Evidence Act. As we said, this is why we are doing this public participation. We are gaining all these comments from all the relevant stakeholders. And rightfully so, now we see there's need for clarity on those issues surrounding which are the regulations that will apply. So those are comments definitely we'll take back as we go to sum up the final regulations. Thank you.
Thanks for that, Carol. We'll either move to Wilfred or back to the podium.
The other question was on fixation, or which question?
The other question was on the arbiter.
Oh, on the arbiter.
Yeah.
So the tribunal has the flexibility to help the parties meet, right? And should the parties, get to a stalemate and they mutually consent that they would like the tribunal now to step in, with that written consent, I think we can do that, right? So that then it's not an imposed sort of situation. One party wants this, the other party wants that. And in the event that's not happening, then we would now switch into tribunal mode and just do what we need to do and give our judgment or ruling based on the law, based on the circumstances we're examining. Yeah.
Okay. There's also the question on pending the adoption of these regulations enactment, where can someone go for redress?
Okay. So even before these regulations, this draft was put out there. As the previous tribunal, we managed to listen to a few matters. We had, in the current Copyright Act and the regulations, there are one or two forms that have managed to help us. They helped us survive. So where there's opportunity for that, I think they take advantage and they come to the secretariat and ask questions. And then we also said that, there is nothing that is refraining parties from actually even them submitting as parties and saying, what, despite the tribunal in its strict sense not having that jurisdiction in the act, right? But we know this is a copyright infringement. We know that the members of the copyright tribunal are competent in matters copyright, in issues of substance of law, application of all these, issues, case law and whatnot. Then they could mutually agree and say, what, I as Joseph, I as Liz, we mutually agree to submit to the copyright tribunal to assist us in this dispute. When we have that, we're as good as done. And I think the greatest advantage you have is the timelines. Just reminding people, IP has a shelf life of a banana. So if you have that dispute that you need to sort out now, there's a deal cooking. We're happy to do that, right? And we have, within when they're filed, we'll just use the default provisions we already have in terms of timelines. Why not? We will make it happen and make sure that justice is accessed. Yeah, but in the meantime, where it's of course of higher value, maybe they'll proceed to the High Court. But when they come to us, because if you look at, I think is it section 33A on, I think 33A on fair compensation, for example, then of us as members, we'll be able to, ask some questions that would help us get information. We'll also be able to do research in terms of assessing fairness, market rate and whatnot. We have access to experts as well from government. The tribunal asks our experts to be from government. And if it's a music case, we'll be calling the, say, PMCC, for example, to come and give us an opinion on something maybe we are hazy about or confused about or whatever. But at the end of the day, even the person who is asking for fair compensation, then they cannot be crazy and exorbitant and unfair or punitive or whatever the case may be, but it has to make sense. And then, make it fair, because the tribunal is supposed to make sure that, parties are able to, settle their matters quickly and efficiently. And if there are instances where they can actually listen, what we call sikizana out of court, they can, go and agree, then so be it. We'll be happy to say, you go talk about it and then come back, tell us what you've decided, and we append a stamp. Yeah.
Okay. There's one more comment that I've seen. It's recurring. So from Ndolo, who's talking about, notwithstanding the limited scope of jurisdiction, is the tribunal able to adjudicate on conflict arising from YouTube copyright strikes? So that's one question. Then I saw the issue of the CS. So let me just also capture that. Good afternoon. Can you discuss why the regulations provide that the appointing authority for the tribunal secretary is the cabinet secretary for the members of its CJ, when the tribunal is the subordinate court of the judiciary? Should the appointment not be under the JSC as it happens for all other judicial officers? So we could tackle the two. And then in case there's anyone who would like to put out their comment, you can just raise your hand and we'll be able to point at you.
So let me first take the second question. We have several tribunals that have already moved under
Yeah.
the judiciary,
Mhm.
copyright being one of them.
Mhm.
So already in practice, we have, like our secretary or our CEO has been appointed by the judiciary.
Mhm.
Yeah, and all the other tribunals, I think they're about 20, 21 that are under the judiciary. That's already happening. We have the tribunals bill that's being tabled, where eventually we will see tribunals fall under judiciary, where they should actually fall.
Yeah.
So that then also in terms of precedents and whatnot, there is no red tape, because right now we are seeing, in terms of other tribunals, accessing precedents has been an issue, and
yes,
I'm sure many lawyers
very
can attest
difficult
to that. So hopefully, as this tribunal is now being tabled, that the lawyers here will support that, because we can see why it's important. But in the meantime, that's what is happening. That's what is happening in our tribunal. We are under the judiciary, under the registrar of tribunals.
Okay.
Yeah.
For the YouTube strikes, is that something that will fall under your purview?
So because YouTube strikes fall within the copyright,
Yes.
because this is someone who is alleging that their content has been infringed upon, and then they lay a strike on YouTube. So of course, with such a dispute, there would be an issue of ownership, right? Yeah. Ownership is under our jurisdiction. We're able to now confirm and say, this is truly their work, or it isn't, is a derivative works, and what should happen, examine the facts and give a pragmatic solution. And even present the case to the parties and say, you know what, already under the law, this is the position. Are you in a position to agree, or would you rather us to, crack the whip, depending? Because again, also information in terms of even copyright infringement in the digital space is still really wanting.
Yes.
So there's a big problem there. So for us, we won't be punitive, because we don't want to punish anyone for ignorance. But at the same time, where there is any illegality or unfairness, we will definitely, call out on it. Already our act provides for, copyright strikes and whatnot. And it states that, in instances where there is a fake copyright strike, then that person would be liable. Yeah, because they also cost someone, they're interfering with someone's right of ownership and control. And at the same time, they're giving possibly false information. This party who's being affected is probably losing money, losing opportunities and whatnot. So that is something that we could listen to. Like I said earlier, let the parties submit to be easier. And if instances they would need an opinion as they're going to the High Court, that is something I think we could also offer, because perhaps at the moment, maybe the other party, whatnot, we would give an objective opinion to guide the High Court, for example. But yeah, we are here to assist matters copyright tribunal.
Yeah. Thank you for that. Any further remarks from my panel? Wilfred, anything on the...
Yes, perhaps a comment on the issue around the YouTube strikes. I think just a small comment, and I think our chair had alluded to this much earlier in her presentation differently. I think one of the powers that the tribunal would have under the law would be to make a determination on matters to do with fair remuneration, where there's an allegation of infringement in copyright infringement in broadcast, audiovisual broadcast, so that whoever would be complaining about the infringement of their work via the YouTube channel need not just pursue that one singular option of seeking, pursuing a YouTube strike, or having, to have the works pulled down. There's an option which would appear to work for, creatives, because then you would be generating income out of it. So that as opposed to pursuing or insisting on having the work pulled down, you would pursue the option that the law allows you now under Section 27, where you file your complaint before the tribunal, and then the tribunal would make a determination on whether or not you're entitled to any fair remuneration and the quantum thereof. So it would be an option that would be available to creatives over and above just pursuing a pulling down. But again, if you look at that provision, there's perhaps need for discussions around an amendment, because I'm not too sure there's very useful logic on why, and I hope I can say this, why it should be limited to just audiovisual broadcast. I mean, it's a very narrow interpretation of what a broadcast is. so that it would rule out potential significant infringements that are available, that would be occurring under radio broadcasts, for instance. So it need not just be audiovisual, so that it limits, again, unnecessarily the jurisdiction that the tribunal would have. But even more importantly, it denies creatives an opportunity to move to a more quicker avenue to resolve these disputes, where they would otherwise then be forced to go to the traditional courts and go through the motions of establishing ownership before now coming down to the whole question of infringement, whereas there would be an easier route to have their legal concerns redressed from that.
Okay.
I think on membership, there's a case at the Court of Appeal that addresses that problem, where the authority to appoint should lie. So I think the High Court Justice Murima had previously ruled that in applying Article 169 of the Constitution, all tribunals lawfully lie under the judiciary and under the office of the Chief Justice, and therefore the appointments to the offices of membership or even Secretary of Tribunals ought to be done by the Office of the Chief Justice, so that the tribunals are properly housed as judicial bodies, and therefore enjoying some autonomy from the executive, which would otherwise have at some point vested interest in appeals that would be before tribunals. So for instance, if you look at our tribunal, the Copyright Tribunal, some of the matters we handle would be appeals against decision of the Kenya Copyright Board, which is a state parastatal under the executive, in either refusing to register or issue a certificate of copyright registration, or where they are declining to register a CMO, for instance, or imposing unreasonable conditions on that CMO. So it avoids that untidiness where the person that is actually declining to grant a license or register a copyright is again the person who is determining whether or not that decision is regular. So it takes away the principles of natural justice. So that even from a perception point of view, it's important to just separate these two offices, which I believe was the reasoning behind the establishment of Article 169. And the High Court appeared to have agreed with that interpretation, but the Court of Appeal has since stayed the application of that particular judgment, so that we wait to see what the courts ultimately decide on that.
Okay, thank you for that. Lastly, I think, Paul, your hand was raised, but it seems not raised anymore. But I can see you put in a question on the issue around fees. So has the tribunal settled on the fees, if any, that will be payable? I believe this is the second schedule, right? Of the regulations. And so, yes, that is provided for. Maybe the question, you guys can go through it and see whether the amount specified there are actually fair and something that we can be able to afford as, general users and Kenyans. And so maybe the comments can be around the amounts that they have issued, but they have definitely put in the fees that are payable in this sense. So yeah, as we are coming to the end of our discussion, which I think has been a very fruitful and useful one, both for us who are, giving feedback on this and learning from the tribunal, and even for them in terms of just putting together comments, I think we can be able to do our last round of comments and remarks from our members here in terms of the expectations, the invitation to collaborate or to work with you as users and holders of copyright. Just any other further input that they may have. There's someone who's talking about being able to access the draft regulations. I'll ask my colleagues to just put it back up once more, share the link one more time so that they can have ease of access for that. And also maybe the deadlines for submission. So I'll start with Helen to my far right, then walk this way, then we'll end, we'll go to Caroline and Wilfred and finalize with Liz. Yeah.
Mine would just be to thank all of you who are able to join us this afternoon. We thank you also for the comments that have come through, which we are going to consider, and also engage the Kenya Law Reform on their input into these draft regulations. We are ready to serve you, and those that have disputes that need to be filed, we welcome you to come and file them. Thank you.
Thank you, everybody, and thank you to Lawyers Hub for this opportunity, and to all the attendees on the webinar. Just perhaps to add on to the person who was asking about the question of our jurisdiction in relation to YouTube strikes. I'd like to say maybe, and this is essentially what copyright law is, it envisages that many of those who want to use others' works engage with those persons to get a license to do what it is that they intend to do. So you'll find that if, for instance, you're a big user of that channel, whatever channel, or for whatever platform, it's highly unlikely that you will continue to infringe on others' rights, and that platform owner does not take you down or shut you down in relation to what they say. And that's much, much quicker than anything that a tribunal would ever be able to adjudicate to you upon. So what we encourage is that copyright is in relation to property rights. And if you want to access people's property rights, then you have to commercially engage them. That's what we're asking. And that's why infringement, it's like any other property you're infringing on. So we would listen to disputes, but we would much rather that the culture of negotiations and commercially licensing takes hold in this country, so that people are able to enjoy the benefits, and those who create it can continue creating what it is that they're creating.
That's a good highlight. I'll move to Caroline and Wilfred.
Thank you very much. I would like to thank the Lawyers Hub for having created this opportunity for us to have this engagement. I also want to thank all the lawyers who have come on the webinar, and your comments are highly appreciated. There was the question on the deadline. I know through the LSK, there was the initial circulation of 3rd March, but we had received requests to ask for an extension up to 8th of March, 2023, and we are open to that. I note it's also been commented, so the deadline for the public participation will be 8th March, and we look forward to receiving more comments, which we are going to consider. Thank you very much.
Thank you. Over to you, Fred.
Yes, I think very briefly, one, I think we can't thank Lawyers Hub enough for facilitating this session and allowing us an opportunity to, as a tribunal, to just engage with members of the public, our stakeholders, the practitioners, creatives. So we appreciate that. Thank you very much, Lawyers Hub. I also want to thank the attendees to this particular seminar. We appreciate the questions that have been put through, the input that would help improve our regulations or the draft rules. So we appreciate that. I think I also want to acknowledge our chairperson, Liz, for her leadership and getting us to this stage. I want to thank my colleagues in the tribunal also for the effort and work that they continue to put in to ensure that we're discharging our mandate. I think just 3 comments as we close. I think it's important, and I think Joseph, my colleague, mentioned this, to ensure that we continue, even as much as we, as a tribunal, are a judicial entity, or quasi-judicial entity for that matter, it's important to enhance this engagement that we have with the different stakeholders, so with Kekobo, with the CMOs, with the creatives, with the advocates, so that we unlock the potential that lies with the creative economy. So that there's a lot of limitations that are there from failure to protect works that are variously created, or even failure to appropriately enforce rights that accrue to the different entities, so the rights that would accrue to creatives or CMOs or whatever. So I think it's important for us to enhance the avenues of engagement within ourselves. As a tribunal, we have a secretariat that is supporting the work that we do under the leadership of our CEO, and as the tribunal, we are led by our very able chair, so that we are open to discussions on how to make the tribunal more responsive and unlock the I believe the potential that lies locked within the creative sector. The other thing would be a general comment on the rules. I think a proposal was made for us to incorporate the Evidence Act in our rules. I think we left it out for good reason, because like our chair was saying, we want to try and have an informal as possible. We want to have an informal tribunal as much as possible, so that we do not limit the ability of parties to appear and present their best case possible before us, but at the same time also having some sort of order on how cases are presented, and parties who are, sued before us as a tribunal are able to adequately respond to the claims that are being made before them. I think the Evidence Act creates quite a bit of hurdles that would make it difficult to achieve that, and quite a number of tribunals have done away. In fact, they expressly oust the applicability of the Evidence Act, so that without an ouster, it would apply. So that it would be important, perhaps, for us as we go back to deliberate as a tribunal, to consider the option of ousting or limiting its applicability so that it doesn't negate the objective of the regulations. We wouldn't want to have rules of procedure that then make it virtually impossible to expedite determination of cases or for parties to even approach and tender the best evidence before us. I think the last final comment is on the question of possible ADR, entrenchment of ADR within the processes of dispute resolution within the tribunal. Yes, as a tribunal, we actually had very extensive discussions on this, where I'm not sure if my colleagues already made reference to this, where we were purposely deciding to ensure that whenever disputes are before us, we try as much as possible to create an opportunity for parties to mediate, and see whether the dispute can be resolved. I mean, because most of the time it's a commercial licensing disputes that can be resolved amicably, or even if it's an infringement question, even if you look at what now Section 27 empowers us to do in determining a fair remuneration. These are issues that can be mediated, and then in absence of that, then we come in as a tribunal to try and offer an impartial way forward. So I appreciate Kekobo has, as amongst the activities that it undertakes, substantively facilitating mediation on disputes around copyright registration, copyright infringement. But as a tribunal, we would be happy to also just plug into that space and enhance, ADR as one of the processes that are available within the tribunal. So thank you very much, and I look forward to parties making use of the tribunal. Thank you very much.
Thanks for that, Wilfred. There's actually one person who's asking about the Court of Appeal case you mentioned on tribunals. Are you able to just cite that one more time?
I can get the citation and share it on chat, but there's the original decision from the High Court was by Justice Mrima, and it's currently on appeal. I'd have to get the exact case citation and share it on the chat.
Okay, that's okay. So I'll hand it over to you.
So Rispa, before I wrap up, I see there's Faith who has their hand up. Could we give them a chance?
You can. Yes, sure. Faith, go ahead. Yeah.
Thank you for the opportunity. So I wrote my question in the Q&A, but I noticed that we were wrapping up, so I was afraid that it was not going to be addressed. So my question is just about jurisdiction. I'm really happy and impressed with the zeal and the psyche that the tribunal has to even address copyright infringement disputes if the parties are willing to subject themselves to them. But we all know that jurisdiction is everything. So isn't it risky as the Copyright Tribunal to immerse yourselves into hearing copyright infringement cases and making determinations? You never know what might happen in future, considering that you have no express jurisdiction to do that. Isn't there a risk? Do you see a risk in future for doing that? I really appreciate it, and I really wish you had the mandate, because some of these cases are really, to just really be handled somewhere by an expert tribunal like yourselves, because I know in the High Court or even in the magistrates' courts, some of the judicial officers may not have the copyright expertise. So it is really good, but without the mandate, I'm afraid. I don't know how you see that. Thank you.
Thank you, Faith, for that. And I said earlier that if the parties expressly submit, if they have an agreement and they say, we have a matter and we submit to the Copyright Tribunal to assist in this dispute resolution outside in terms of the strict application of the Act, because we are a dispute resolution body, there's nothing that is restricting us from doing that. If both parties are happy with that, I think it's well and good. So and that's just a solution we are offering so that people don't feel stuck. right? Because right now we have a lot of people feeling stuck, and yet we are here. So in the absence of, these amendments we hope to have, I think there is wiggle room for that, because we have a competent tribunal who have understanding of copyright matters, including infringement. If the parties submit, like what we do in arbitration, right? You literally submit to our competence, then that is something that we would, because that also means that you would happily respect the judgment that we put forward, and you will proceed and do what is needful. So I think in my parting shot, I'd like to say that we extended the deadline to 8th March. However, for those who are giving input through LSK, the deadline would be 3rd March, so that LSK has a period to consolidate and then submit by that 8th. But if you're submitting in your personal capacity, 8th would be the deadline. We will have a Twitter space on the 2nd of March, another collaboration with Baraza Media Lab. So you're happy, feel free to attend. We're also targeting even non-lawyers to be part of these conversations. And so encourage your friends, your clients, and anyone who copyright affects their day-to-day business to be part of those conversations. I think lastly, I would like to thank Lawyers Hub. Thank you so much for this collaboration, and we don't take it for granted. We want to thank you participants for showing up, for being with us and sharing your questions and sharing your input. We shall definitely take them into consideration, and we shall have, we'll also then prepare a subsequent report and, highlighting some of your concerns and say what was not included, why, so that also as you go forward, as you are part of public participation, you're able to understand, what is going on. And then we want to also thank Registrar of Tribunals and the Judiciary for also the assistance that they've been according us to be able to, operate and be here and continue pushing as a tribunal. So we look forward to more engagement. We'll definitely have more copyright conversations. This is a first of many. So we want to say thank you, and we will be receiving your comments.
Yeah. Yes, Joseph. This question about jurisdiction is really...
the question is not going away.
Yeah. So Jacqueline is asking, in a follow-up question, will the judgment, ruling, or award given have the full force of the law?
Look, the risk of perhaps it's always important for a tribunal based on law to act within the law. I would much rather that the jurisdiction was enhanced. So it's not encouraged that, or neither would have serious difficulties having anything that is outside of our jurisdiction being had by us. That is my view, because we know the law from the beginning. We have been told without jurisdiction you cannot hear dispute, because it doesn't matter even how well you handle it. It doesn't matter how neat you handle it. If you shouldn't do something, don't do it. That's my view about it. So maybe to assuage the question about the risks, it is something that we would not be engaging in, at least for my part, on that question until maybe Parliament has deemed it that we should have a jurisdiction which can be enforced, and which obviously we know we are subordinate to the High Court and the Court of Appeal. We wouldn't want to be engaging in activities that then are not within our ambit and within the law. So as much as possible, parties, if you would like to come to us, perhaps we'll refer you to somebody else who then is out there, who can then listen to your dispute, whether it's an arbitration center, whether it's an arbiter, whether it's an association of arbitrators, somebody out there with a force of law that then you can then be able to take your consensual judgment, and then that can be enforced. For us, our jurisdiction is as listed under the Act, and unfortunately, that's all we can do.
I think just one thing to say also, I think we have been very careful in the copyright space, and we are suffering from a lack of precedence. So me, I'd say, let's do, like, bring it, we discuss, that's how we build jurisprudence, right? So I'd say have a fearless approach. If you think something could work, let's try it. And then it doesn't, there'll be an appeal, there is no loss, for us, we will not fear an appeal, or we shouldn't fear an appeal, because we're trying to pursue to have a robust copyright system. So I think as we hope and pray that our mandate would be expanded and things would move quick, fast, and in a hurry, I think in the meantime, let's explore, let's build jurisprudence, because that's really what we need at the end of the day. So I think I agree with Kihanya, what he has said, but at the end of the day, for the lawyers here, if you see something, we just try. At the end of the day, if your principle is access to justice, I mean, I think if that's the anchor, I don't know how it would fail, but let's build jurisprudence. That's what I'm basically saying. Yeah.
Okay. Interesting. I don't want to make a bad joke, but I was to make a joke around conservatives versus Democrats, and maybe that's how that will pan out. Yeah, but I think
let's answer directly in one way. There was a question. I think it's left hanging whether the decisions of the tribunal are binding. I'm not sure. I don't think we've answered her. Yes, I think the simple answer is yes. The determinations by the tribunal on any issue enjoy the full force of the law. Deriving its authority from Article 169 and Section 48 of the Copyright Act. So yes, the decisions of the tribunal are as good as decisions of any other court with proper jurisdiction on any specific issue. Yes.
Okay. Thank you so much to my able panelists. Of course, we must take a photo. We must show that you are here. So Caroline and Wilfred will be spotlighted, and then we can just take a quick screenshot or photo. My media guys, just tell us when to smile. Oh, 3, 2, 1, smile. Awesome. Thank you so much to everyone who's joined us this afternoon. It was such a privilege and honor to have you with us. Thank you for your comments and your remarks. We'll definitely put that into consideration as we are compiling our own submissions. Be sure to also, put out your own, whether it's in liaison with the LSK or in your individual capacity. We have a lot of time. Actually, it's one of the few regulations that I've seen that has quite a period and chunk of time to be able to submit. Many they give you almost like a week or two to be able to do so. So thank you for that. Thank you for joining us and availing yourselves to answer all these questions. Thank you for the team at the Lawyers Hub. Thank you for everyone who's been with us this afternoon. And with that, I think we can wrap up. Enjoy the rest of your day. Have a fruitful week ahead, and let's see you at the next Policy Monday.
Privacy professionals are becoming crucial for the running of any organization. And this is why it's important for lawyers to develop their data privacy knowledge or practice in the area of privacy law. For the first time ever, the Lawyers Hub will be offering a monthly 4-day training on data protection that is certified by the International Association of Privacy Professionals, IAPP, the world's largest, most comprehensive global information privacy organization. Upon successful completion of this training, you will be awarded with a certification from the Africa Digital Policy Institute and the Lawyers Hub, and be eligible to sit the IAPP exams for certification as a privacy professional. Register for this training and become certified as a specialist in privacy law. For more information about this training,